For Senate Enrolled Act 24, it amends IC 27-10-2-12, IC 35-33-14-1, and IC 35-33-14-2. And it also has a related non-code section. Effective July 1st, 2013, there will no longer be a county extradition fund. Instead, there will be a fund called County Extradition and Sheriff's Assistance Fund. And that will be on your new chart of accounts listing. Per the non-code, it says that any money in the County Extradition Fund on June 30th should be transferred to this new fund. We are not going to actually create a new fund number for that. We are going to just change the fund name. The reason is that really they're just expanding the uses, they're not restricting the uses. And so since they're so closely related, we determine that it won't be necessary to do a transfer from one fund to another. The source of the receipts in the fund will be the same as what went into the County Extradition Fund. This is found under IC 27-10-2-12, and it's late surrender fee that is assessed against a bail agent or surety bond when a defendant does not show for a recognized cause. 50% of the late surrender fees still go to the Police Pension Trust Fund, and the remaining 50% will go to the new County Extradition and Sheriff's Assistance Fund. As the extradition fund, it was just used to provide funding to offset the costs of extradition for criminal defendants. That has been expanded and now may also be used to provide funding to train and equip law enforcement officers of the county and to provide funding to offset other costs incurred by the county sheriff's department in providing law enforcement services. So it'll be another funding source for expanded uses for the sheriff's office. Senate Enrolled Act 32. It's effective July 1, 2013, and it amends IC 36-2-2-6, and it changes the dates of regular executive meetings when they need to be established. Before, it was in the first meeting in January, and now it may, the resolution for these meetings may be at or before the first meeting in February of each year. Senate Enrolled Act 33, this brings into line the statute with what has really been occurring in fact. IC 36-2-13-5.6 was amended effective July 1, 2013. This has to do with the sex and violent offender fees. The wording of the statute before indicated that when this money was transferred to the county auditor, that the county auditor would monthly deposit 90% of the fees collected into the county sex and violent offender administration fund and transfer 10% to the state of Indiana. Now 90% will still be deposited monthly to the county sex and violent offender administrative fund, but you would transfer the 10% to the state of Indiana semi-annually, which is really consistent with what I think that we're pretty much doing anyway, but I think there was a little bit of controversy since it did say monthly. I keep doing that, sorry. Senate Enrolled Act 125 is effective July 1, 2013. Add a new article, IC 16-49, which creates a child fatality reviews, and it creates a team that's made up of the prosecuting attorney, county coroner, county health department, some law enforcement personnel. And the one thing I want you to take away from this is that it establishes that training expenses for the members of the local review team are paid by DCS, so by the state. Senate Enrolled Act 152 and House Enrolled Act 1545. That's on the interest for refund of property tax, and I will be talking about that in detail this afternoon, so we want to go over that. House Enrolled Act 1545 and House Enrolled Act 1145 amend IC 36-1-8-5.1 effective July 1, 2013. This changes transfers in regard to rainy day fund. Before, it said in any fiscal year, a political subdivision may transfer under Section 5 of this chapter not more than 10% of the political subdivision's total annual budget for that fiscal year to the rainy day fund. And subsection 5 refers to funds raised by general or special tax levy on taxable property. And it states, whenever the purposes of a tax levy have been fulfilled and an unused and unencumbered balance remains in the fund, the fiscal body of the political subdivision shall order the balance of that fund to be transferred as follows, unless a statute provides that it be transferred otherwise. And funds of a county to the general fund or rainy day fund of the county. So up to 10% of the annual budget could be so transferred to the rainy day fund. And this has been expanded. Now it reads, in any fiscal year, a political subdivision may at any time do the following: transfer any unused and unencumbered funds that are specified under Section 5, which we just talked about, and also from the Cadget, COIT, and CEDIT, if that's specified in the rainy day fund. And also transfer any other unobligated cash balances from any fiscal year that are not otherwise one of those that I've just talked about. The amount of the transfer for these others is authorized and identified in an ordinance or resolution for the rainy day fund, and the amount of the transfer is not more than 10% of the political subdivision's total annual budget. And the transfer is not to be made from the debt service fund. So there has been a little bit of a twist to that. It's a little bit, actually a lot different. House Enrolled Act 1145 amends IC 36-1-8-11, effective July 1, 2013. IC 36-1-8-11 provides that the fiscal body authorizes the methods of payments accepted by the county, except for the treasurer's office, and this may include acceptance of credit cards and debit cards. Before, the statute allowed that the county could collect a fee from the person using the credit card, an amount that did not exceed the amount charged to the county. Now, the county can either or both do this. They can go ahead and charge that amount, and they can charge a reasonable convenience fee. So you can do both of those things. The convenience fee may not exceed $3, and it must be uniform regardless of bank or credit card used. These fees may be collected regardless of the retail merchants' agreements between the bank and the credit card vendors that may prohibit those fees. So regardless of what they're saying, it still can be done. The statute does not specify where this fee is to go, and so it's our position then that it would go into the general fund. I'm going to just take a little moment here and say this. Senate Enrolled Act, you don't have a slide for this, 226 is about a study committee on topic of suspension of elected officials charged with a felony. And that's charged, and as now we know, if you have committed a felony, you can't hold the office. But I'm sure there's going to be a lot of different things discussed this summer. I notice there's a lot of study committees, and that's something that the AIC will be working with you and your association about. Senate Enrolled Act 243 amends IC 5-14-3-4. It's effective upon passage, which was May 7th, 2013. This is in regard to exceptions to disclosure of public records under IC 5-14-3-4, subsection B, which is where the public records are expected to have disclosure at the discretion of the public agency. It was added that the home address, home telephone number, and emergency contact information for any emergency management worker, public safety officer, emergency medical responder, or advanced emergency medical technician could be excluded from disclosure. House Enrolled Act 1219 is along similar lines. It adds IC 36-1-8.5, which is a new chapter, effective July 1, 2013. The implementation does not begin until July 1, 2014. It allows, but it does not require, that a county that operates or contracts for public internet website database containing the name and addresses of property owners to establish a procedure to permit a law enforcement officer, judge, or victim of domestic violence to restrict disclosure to the general public of these persons' home address upon their request. And if the county chooses to do so, this statute provides the requirements that are needed and also has required process. Senate Enrolled Act 249 established, it's effective July 1, 2013, and adds a new chapter, IC 5-11-20. It provides for retirement plan reporting to State Board of Accounts, another thing that you get to report to us. This will be done at the same time that you report your 100R, and actually the questions are embedded with the 100R. We're still working on that, and so this fall we will train you on what the questions are and what kind of information that you'll need to be providing for that. Senate Enrolled Act 275, effective July 1, 2013, and amends IC 6-1.1-24-1.2. This is in regard to removing real property from the certified list before tax sale when the taxpayer and the county treasurer agree to an arrangement for the payment of the delinquent taxes. Before, that statute said that the county auditor may remove. Now it says shall remove. When the conditions are met, and under the conditions there was an addition, so the county auditor shall remove the tract or item from the list certified if the payment arrangement between the taxpayer and treasurer is in writing, signed by the taxpayer, requires the taxpayer to pay the delinquent taxes in full not later than the last business day before July 1 of the year after the date the agreement is signed. And the new part is that the county treasurer has provided a copy of the written agreement to the county auditor. IC 6-1.1-33-9.7 is also amended, effective January 1, 2014. This allows for monthly payments of property taxes. Under subsection F, it said that the county fiscal body may at any time adopt an ordinance to allow all county taxpayers to pay one or more installment of property taxes by making payments under a monthly payment plan during a designated payment period. Effective in January, it is added that if a county fiscal body does not adopt an ordinance under this section, the county treasurer shall develop and implement a plan to accept partial payment of property taxes. The county treasurer shall notify the taxpayers on the property tax bill or the envelope used to mail the property taxes. So essentially, it's going to allow for monthly payments one way or the other. It's saying it's either going to come through the county fiscal body or it's going to be the county treasurer. So. Senate Enrolled Act 343, effective January 1st, 2014. That's not a typo, it really is 2014. Amends several sections of IC 36-1.5-4. This chapter has to do with reorganization of political subdivisions. There are various changes to the reorganization process. One is that it eliminates the reorganization committee. The legislative bodies are to prepare the reorganization plan. The plan must include several new elements, including a fiscal impact on both those included in the reorganization and outside of the reorganization. DLGF is to review this information before it can go on a ballot as a public question, and they also review the public question. And it also makes changes to the process that the voters must use when initiating the reorganization. So this is something you should talk with your county attorney and the DLGF if this is something that occurs in your county. Senate Enrolled Act 415, effective upon passage, which was May 7th, 2013, amends IC 4-12-7-4 and 4-12-7-5 and 6. This has to do with the funding provided by the Indiana Department of Health to the local boards of health. Before, the distributions of funding came from the Indiana Local Department of Health Fund by the state to the local boards of health, and it was an automatic process. It was based on a formula that was by statute. Now, IC 4-12-7-5 requires that the local Board of Health file an application with the State Department of Health for their funding. And before October 1st of each year, they need to do that, and it has to specify the planned uses of the fund. The State Board of Health will provide the manner that the application is to be submitted, so hopefully they've already been in contact with your local boards of health. There will be 2 distributions instead of 1. Before, there was just a distribution on July 1. Now there'll be one not later than January 1 and one not later than July 1st. And of course, this is a transition year. And so the application due in 2013 covers a period of 18 months, and it must be submitted by June 1, 2013. That's why hopefully they're already been working together about that. The first distribution will be by July 1 of this year, the next one by January 1 of 2014, and the final one by July 1 of 2014 under this plan. IC 4-12-7-6 was also amended. Before, if there was only one Board of Health in the county fiscal body would appropriate the funds distributed to the county to the local Board of Health. But if there was more than one, then the county fiscal body would appropriate the distribution from the state to the boards of health in amounts determined by the county fiscal body. This is no longer the case. Again, those boards of health with the proper application are the ones who will receive the distribution, and if there's more than one board of health, then it will be the Department of Health that will determine the distribution and not the fiscal body. Senate Enrolled Act 433, effective July 1, 2013. And this provides for violation of weed ordinance IC 36-7-10.1-4 was amended. So first of all, let's see, it can now be sent by first-class mail and not certified mail. So there's one change there. And it was also amended so that if the owner of the real property fails to pay a bill for the actions taken with the ordinance, the bill collection has now been expanded. The county or municipality may bring an action in appropriate court to collect the amount of the bill, plus any additional costs incurred in the collection, including court costs and reasonable attorney fees. And if you obtain a judgment, you may attain a lien in the amount of the judgment on any real or personal property of the owner. So that's an expansion. Right now, if the bill is not paid, the amount plus the administrative costs are certified to you, and the amount is placed on the tax duplicate for the property affected and collected as the delinquent property taxes. So just gives a little more avenue to take. IC 6-1.1-7-10 was amended. This is about mobile homes to provide that when a county treasurer issues a permit to move a mobile home, the treasurer is to notify the township assessor of the township to which the mobile home will be moved, or the county assessor. And if, let's see, and then effective upon passage, which is May 8th, 2013, IC 6-1.1-7-16 has been added. The DLGF will develop a system for recording the property tax information for a mobile home assessed under this chapter, and in that implementation will be January of 2015. Also, IC 9-17-6-17 has been added, effective July 1, 2013. It provides that with a purchase contract for manufactured home, and they've expanded it under that code to include the meaning of mobile home, the seller must provide a copy of the title to the manufactured home, and the contract must specify whether the seller or the buyer is responsible for the payment of the property taxes assessed against the home. The buyer must record the contract with the county recorder's office. And so you'll have recorded in the recorder's office the affidavit stating who is going to be responsible for the property taxes, and the title, as well as the affidavit. This part changes real property that has been abandoned or is vacant. IC 6-1.1-24-1 was amended effective July 1, 2013. Under subsection A2, where the county executive certifies to the county auditor real property that is vacant or abandoned, it has been added that the executive of a city or a town may provide to the county executive of the county in which the city or town is located a list of real property that the city or the town has determined to be vacant or abandoned. The county executive shall include the real property included on the list provided by a city or town on the list certified by the county executive to you. So that could expand that. Also, IC 6-1.1-24-4.5 is amended. It requires that the county auditor to prepare a list of tracts or items of real property located in the county for which the fall installment of taxes for the most recent previous year is delinquent, not later than 106 days before the date on which application for judgment and order for sale is made. The auditor will either submit a copy of the list to each city or town within the county or make the list available on the county's internet website. So that's kind of a big change there. IC 6-1.1-24-6 was amended. This is when a lien is acquired by the county executive after a tax sale. Whenever the county executive acquires a lien under this section, the county auditor shall provide a list of the liens held by the county to the executive of the city or town who requests the list or posts the list again to the internet site. And it shall be done not later than 30 days after the tax sale. So, IC 6-1.1-24-6.2 was also amended for property that is located within the boundaries of a city or town. Before the county executive may transfer the property to a nonprofit organization as allowed under the statute, or allow vacant property to be incorporated into an adjacent property, the transfer that is allowed is a new section. The county executive shall notify the executive of the city or town in which the real property is located of the opportunity to accept a transfer of the property to the city or town as negotiated between the city or town and the county. I kind of got the feeling from this statute that the cities and towns were saying, hey, you know, consider us. And I don't exactly know all of the background to it, but it definitely appears that they want more communication when it comes to these properties. IC 6-1.1-24-6.9 has been added and gives the county executive another option to transfer property that they have a lien for. In this case, by resolution, the county executive may transfer such property to a person able to repair and maintain the property if in the public interest, and a notice is to be published for hearing and specify that the executive will accept applications by persons able to repair and maintain the property. After the hearing, the county executive will by resolution make a final determination considering that property to be transferred and the terms. And that statute provides what some of the terms must be to be included in that. And it also talks about what are the conditions when it'll revert back to the executive if the conditions are not met. For these properties, the delinquent taxes, special assessments, penalties, interest, and costs of the sale is to be removed from the tax duplicate, and the person is entitled to a tax deed if the property is not redeemed. So that part's pretty normal. So it seems like there's going to be a lot more communication list-wise and some additional flexibility for the county executive for the properties. House Enrolled Act 1568, effective July 1, 2013, amends IC 6-1.1-24-6.8. This is the statute that allows for the sale of vacant properties to adjacent property owners. There is a change in what is considered a vacant property. Now it includes parcels that have been improved, and if a structure that may be lawfully occupied for residential use and or if a structure used in conjunction with a structure that may be lawfully occupied for residential use. and the parcel is on the list of vacant or abandoned properties certified by the executive, or not occupied by a tenant or person having a substantial property interest, a public record in the parcel. So it does expand what can be considered vacant. Also, some change to the ordinance by the legislative body concerning this. Before, it said that the county legislative body may, by ordinance, establish criteria for the identification of vacant parcels to be offered for sale, and it and it was supposed to give the details criteria. Now it's added that the county legislative body may adopt an ordinance authorizing the sale of the vacant parcels. And before it was for $1, and now it's to be for $1 plus the amounts that are an amount prescribed by the county auditor that equals the sum of the greater of $25 or postage and public costs, and any other costs incurred by the county that are directly attributable to the tax sale. So now you can't just get the property for $1. You got to pay the cost too. Somebody complained out there, didn't they? So. Also, there is added IC 36-7-17.1, effective July 1, 2013. This is really an additional program that you can do. It's very similar to the urban homesteading program found under IC 36-7-17. So I would look at it, the fiscal body of a unit may by ordinance designate an agency or a corporation or establish a new agency to administer an urban homesteading program. So if that's something your county is interested in. House Enrolled Act 1359, effective May 15, 2013. It adds to the ability of the Redevelopment Commission. It adds IC 36-7-14-49 through 62. It is similar to the Commission's ability to establish a program from housing under IC 36-7-14-45. In this case, a commission may adopt a resolution to establish a program for age-restricted housing. Senate Enrolled Act 517 is effective January 1st, 2014. It amends IC 6-1.1-10-2, which exempts property owned by the state from property taxation. It has added that real property leased to a state agency is exempt if the lease requires the state to reimburse the owner for the property taxes. Also amends IC 6-1.1-15-1, effective July 1, 2013. This is in regard to the $50 penalty that is assessed against the taxpayer if the taxpayer fails to appear for hearing on their appeals for assessment. Before, there was some kind of confusion about the collection process. This makes it clear that it may not be collected on the tax bill. So it'll be through the assessor's office. IC 6-1.1-20.3-13 is effective upon passage, which was May 11, 2013. It was amended, and it's in regard to the protected and unprotected funds, and Dan Baston will be speaking to that tomorrow afternoon. So just to let you know that the passage was for May 11, 2013. IC 6-1.1-36-17 was amended, effective July 1, 2013. This is in regard to when a property is determined not eligible for the homestead, the auditor is to send a notice to the taxpayer of the taxes, penalties, and interest due, and that the amount is to be paid in full in 30 days. and the amount collected was to be deposited in a non-reverting fund. That has been amended so that with the exception of Marion County, which still must put it all in the non-reverting fund, the amount collected is put into the non-reverting fund to the extent that the amount collected after deducting the direct costs of any contract and contract-related expenses under which the contractor is required to identify homestead deduction eligibility does not cause total amount deposited in the non-reverting fund for the year during which the amount is collected to exceed $100,000 or into the general fund for the amount that collected that does exceed the $100,000. So it won't all go into that fund. It will now go into the general fund and it goes into miscellaneous revenue. Senate Enrolled Act 544 has been amended, and it's the Cadget, CEDAT, and COET. It's really regarding changes or implementation of these taxes, and it's made some date changes for this. Before it said that an ordinance adopted after 12/31 of the immediately preceding year and before 10/1 of the current year takes effect on October 1 of the current year. This was changed to adopted after 12/31 of the preceding year and before September 1 of the current year, takes effect October 1 of the current year. And also now an ordinance that's adopted after August 31st of the current year and before November 1st of the current year takes effect on January 1 of the following year. It has also been added that if the Commissioner of the Department of Revenue determines that an ordinance was not adopted according to the requirements, then the Commissioner will notify the County Auditor that the ordinance was not adopted according to the requirements and specify the corrective action that must take place for the ordinance to be in compliance, and the ordinance may not take effect until that corrective action has been taken. Also, additional information is being provided by the budget agency, and the county auditor is required to provide additional information. So there's a little bit more going into the statute. Prior to the amendment, before August 2nd of each calendar year, the budget agency certified to the county auditor the amount determined to be distributed. Now, before August 2nd, the budget agency will provide to the county auditor an estimate of the amount determined to be distributed on the known tax rates. And then not later than 30 days after receiving the estimate of certified distribution, the county auditor shall notify each taxing unit of the estimated amount of distributive shares. Before October 1 of each calendar year, the budget agency shall certify the amount of distribution, and not later than 30 days after receiving the notice of the amount of certified distribution, the county auditor shall notify each taxing unit of the amount of distributed shares. So hopefully that might tighten things up just a little bit there. House Enrolled Act 1001, in regard to inheritance tax, it adds IC 6-4.1-10-1.5 and amends IC 6-4.1-11-6. These are both retroactive, effective January 1, 2013. Last year we had that bill where it was going to gradually reduce the amount that you would receive that's passed to the county. They've sped that up very much, greatly. Now this will be the final year. Before August 15, 2013, the state will distribute an inheritance tax replacement amount to each eligible county. This is in respect to inheritance tax collected that occurred in the state fiscal year 12-13. that will be the last distribution. As a complement to this, IC 6-4.1-10-1.5 was added, which is in regard to refund of inheritance tax. And it states that this section applies to a refund of inheritance taxes paid with respect to an individual whose death occurs in 2013. The entire amount of a refund must be paid by the department, including any amounts retained by the county under IC 6-4.1-9-6. If a county is eligible to receive an inheritance tax replacement amount under IC 6-4.1-11-6 in 2013, the amount of the replacement amount must be reduced by the amount of any inheritance taxes retained by the county with respect to an individual's death who occurs in 2013. And if a county is not eligible to receive an inheritance tax replacement amount in 2013, the department may deduct deduct the amount of any inheritance taxes retained by the county with respect to individuals whose death occurs in 2013 from any distributions of revenue to the county. So that's how they're going to even it up. So you just might want to be aware of that. Also, IC 6-5.5-8-2 was amended effective July 1, 2013. This is in respect to distributions to the county from the Financial Institutions Tax Fund. Before, it was distributed 4 times a year, and now it's going to be distributed twice a year. 50% will be received before December 1 and 50% before June 1. And also there was a supplemental distribution made on or before August 1, and that won't be done anymore. Let's see. House Enrolled Act 1016 amends IC 33-23-16-23. And before, this was where you had the problem-solving court, and the clerk was to transfer, or the court was to transfer over to the clerk the funds, and then the clerk would transfer to you. And now you would be expecting that the court will be transferring directly over to you. So just to give you a heads up for that. Let's see. Okay. The rest of it, I think the slides are pretty self-explanatory. I will have to say, like I said, there seems to be a lot of small but very impactful changes, especially with those lists and their due dates and everything. So when it comes to selling a property, lists that you got to provide and everything, you really want to look that over and see what kind of changes have been made so that you can be in compliance with the law. Now I want to bring up Andrew. He's going to go over one of those stats.